At this time. And again, deep breath for all of you. Enjoy yourself. You guys put a lot of time and hard work, and I know that you have, and we're excited to hear from you. So at this time, I'll hear from our bailiff. So Allie?
Hear ye, hear ye. This court is open pursuant to adjournment. All having business before this honorable court. Draw near, give attention, and you shall be heard.
All right, thank you. Statement that I'd like to make as behalf of the judges who are here as scoring judges and the presiding judge. I do want to let you know that, we all have feelings and assumptions and perceptions, fears and stereotypes about each other's. Some biases we are aware of and others we might not be fully aware of, which is why they are called implicit bias or unconscious biases. As participants in this Ohio mock trial program, it is so important to resist jumping to conclusions or acting upon personal likes or dislikes. Resist letting bias or prejudice and public opinion influence your behavior inside or outside a courtroom. Treat all individuals with respect, regardless of ability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. And so at this time, again, Allie, I'll ask for all my witnesses to either present in your room there with your prosecution team, and the others come on our Zoom, and I'll ask our bailiff to swear you in at this time. So if we can have all our witnesses. Thank you, Meredith. And who is our second witness? I don't see from the defense.
Rachel Thayer, yeah.
She is. All right, very good. I'll ask my bailiff. Bailiff, my right hand, Allie. Let's do it.
Please raise your right hand. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Your testimony will comply with the rules of the Ohio mock trial competition.
I do. I do.
All right, thank you. Again, I'll ask that you be seated, be mindful of your microphone, and at this time, we're going to begin. I'll ask my two timers. Are you prepared and ready to go?
Yes.
All right, very good. So at this time, the parties prepared for their opening statements?
Yes, Your Honor.
Your Honor.
All right, very good. I'll hear first from defense since it's your burden here today. Thank you.
Thank you, Your Honor. Your Honors, opposing counsel, may it please the court.
Thank you.
Ladies and gentlemen, one of the core pillars of our judicial system is the protection of individuals from the state. For decades, we have well-established rules and regulations that ensure that anyone can have the tools and abilities to be able to defend themselves against the state who has unlimited money and resources. We have further enforced these rules by setting legal precedent through different court cases. Cases like Brady v. Maryland, which states that any prosecutors, state or otherwise, are required to turn over all material evidence favorable to the defense within their possession. Cases like Campbell v. Marshall, which found that the choice to enter a plea deal must be made knowingly, intelligently, and voluntarily. What we are dealing with today is how the state of Buckeye failed to uphold these principles. The state of Buckeye allowed a 16-year-old child to enter a plea deal while in possession of evidence that may have exonerated them. On October 15, 2019, Micah Opasay entered a plea deal that charged them with manslaughter and sentenced them to 10 years in prison. However, this plea deal was not entered knowing the full scope of the case at hand. Throughout the whole process, Micah Opasay maintained that they were innocent, which is why they rejected the first plea deal offered to them. However, like anyone, Micah had a breaking point. The state continued to maintain that they had a collection of evidence placing Micah at the crime scene, along with an eyewitness confirming this. It was because of the inclusion of the eyewitness that Micah's legal team advised them to accept the second plea deal offered to them. Due to the state's negligence to inform Micah's legal team on the updated information pertaining the eyewitness, Micah was advised on an issue that no longer existed. Due to the state's negligence, Micah was pressured into a confession, as they were led to believe it was their only way out. The prosecution maintains that the eyewitness's change of heart would not have affected the final outcome of Micah Opuse's case. What this fails to acknowledge is how the state is required by legal precedent to turn over all material evidence favorable to the defense within their possession. So today, the defense will prove that Micah Opuse was not allowed the full breadth of the case to aid in their decision. The defense will first call Micah Opuse to the stand. There they will explain how the argument the prosecution will cite as the catalyst for this murder was nothing more than simple teenage drama. Micah will then confirm how the only reason they accepted the plea deal in question was because they were led to believe it was their only hope of freedom. The defense will then call Miss Charlie Wynn, a private investigator hired by Freddie Sticks, to the stand. Miss Wynn will then explain how all of the other evidence that was used to convict Micah was circumstantial, inconclusive, and not adequate enough to convict any person. They will also confirm how the defense had tried to get in contact with Corey Abrams, but no response was ever received. Ladies and gentlemen, we are here today for a very simple reason, and that is this: to request that my client has the chance at a fair trial with all the evidence on the table. That is why at the end of today's trial, my co-counsel, Parker Badat, will come before you and request that you grant our motion to withdraw Micah Opuse's guilty plea. Thank you.
Thank you. You know, Ms. Becker, I may ask that you just pop on and stay on the whole time as well, if you don't mind, as the timer. Thank you. Thank you. And now we'll hear from opening statements from the prosecution.
Yes, Your Honor.
Thank you, Mr. Jones.
Your Honors, may it please the court and opposing counsel, the state respectfully requests that the defendant's guilty plea withdrawal be denied. On August 31st, 2019, the defendant was responsible for the killing of Hamea Robbins. The defendant was feeling betrayed by the innocent Hamea leading up to that night, after they had gotten into a relationship just after turning them down. Fueled by betrayal and unsettling feelings, the defendant decided to meet up with the unsuspecting Hamea at a popular food truck area. After spending at least 30 minutes with Hamea, they reported that they went to a park for another 30 minutes afterward, which can't be confirmed by anyone. Just after the accused reported that they were leaving the park, a person matching their description was seen fleeing the scene of Hamea Robbins' murder while holding a gun. The defendant chose to knowingly and voluntarily take a plea deal and take responsibility for the actions they did on that terrible night, only to withdraw that guilty plea a year later. But justice was served and must be upheld. The defense must prove two things to the court. The first being that the defendant did not accept a plea deal knowingly and voluntarily, which by denying the first plea deal given to them, they knew that they had other choices. And by taking the second, they waived their right to a fair trial knowingly and voluntarily. The second thing the defense must prove is that the eyewitness testimony was enough to call a not guilty verdict. However, the testimony in question didn't even have close to a large enough impact on the case to enact Rule 32.1, not following the definition of a manifest injustice, as a plea withdrawal should only be done in the most extreme of circumstances, which this case plainly is not. Corey Abrams, the eyewitness in question, has said that they only saw the suspect for a brief moment, not mentioning the fact that it was dark and the suspect was a fair distance away. Today, we will bring two witnesses to the stand. The first being River Foley, who will bring facts to the case, showing that not only the fingerprints taken off of Hamea's glasses, the shoe print at the scene of the crime, and the fibers found on Hamea's clothing were all heavily showing that the defendant was the culprit, with the eyewitness testimony only being something that slightly helped in the grand scheme of things. Meaning that even without the eyewitness testimony from Corey Abrams, there would have still been more than enough evidence to convict the defendant. The second is Ty Robbins, the victim's parent. After what they had to endure throughout the past year, they'll be giving what they noticed about the accused, from a burst of anger lashed out at Haumea to his past and what he had already done. I just have to ask you to look over what happened in a fresh state of mind, seeing the truth for what it is, and make the responsible choice by denying the defendant's plea withdrawal. Thank you.
Thank you very much for your opening statements for both of you. At this time, on behalf of the defense, does the defense want to call their first witness?
Yes, Your Honor. The defense would like to call Micah Opusay to the stand.
All right, I'll remind the witness that they're under oath at this time, and then you may inquire of this witness.
Okay, thank you, Your Honor.
You're welcome.
Could you state your name and occupation for the record?
My name is Micah Opusay. I am 17 years old, and I'm a former student of Trillium High School.
And could you tell me about your experience at Trillium?
Well, it was pretty good overall. I mean, I got on pretty well with all of my teachers, and I had my best friend by my side for most of the way. I mean, I did get into some trouble here and there.
And could you just explain for the courts what that trouble means?
I think there were two major incidents. One of them being there was an incident with marijuana possession, and another one with there was an 18+ nightclub opening up, and some of my older and like same age friends were going, so we got fake IDs and we got caught.
Okay. I want to just talk about your relationship with Haumea. Could you describe that?
Yeah. So Haumea was great. I loved her a lot. She's my best friend, obviously. We got on really well for a really long time. I had some trouble because her parent didn't seem to be the biggest fan of me. I definitely remember many incidences of not feeling very welcome in their home, but it was okay. I mean, we got on really well until 8th grade when we met our friend Scout.
And how did things change after that?
After we met Scout, we were all pretty close, and then they started hanging out a lot without inviting me, like even to class projects. They would go bowling together and things like that, and it was okay because I would still hang out with Haumea, but eventually it just became them together and me. And then at some point I even confessed my feelings for her, and she told me that she didn't want to ruin our friendship, and I mean, it hurt a lot, obviously, but I really understood that until a little while later when she started dating Scout.
And how did you react to that in the days following?
It wasn't one of my proudest moments, I guess. We had a bit of a blow up, and I said some really nasty things to her that I definitely wish I could have taken back because I didn't think them through at all. And it led to us not talking for about a month, I guess.
So after that 1 month point, what was the first encounter that you guys spoke again?
I reached out to her at some point, and we agreed to meet up at one of our favorite food truck places at the park, and that's when we talked things out, and it was great. I was really hopeful for our relationship, and she dropped her glasses like she always did, and we joked about it, and I gave her a hug that I didn't know was going to be my last, but it was really hopeful for the future of us.
And I know this might be difficult, but could you just talk about the days after that event?
Yeah, so after that, I gave her some space. I gave her some space.
One moment. Was
Um,
there an objection?
Yes, Your Honor.
Okay. Sorry about that. Go ahead. Your objection?
The question called for narrative.
Reply to that, Parker?
Well, I believe this line of questioning was pertinent in explaining further subsequent action, and it wasn't narrative. It was actually answering the specific questioning that I intended to ask.
Yeah, I'll note that this is direct examination of this witness, so I'll overrule the objection and I'll allow the line of questioning to continue. Thank you for both of your arguments.
Thank you, Your Honor.
Thank you, Your Honor. So, again, could you just explain what happened in the days after?
Yeah. So after that, like I said, I was giving her space to think things through, since it was a pretty big fight we had, and I actually got called down to the police station, which really like confused me. I thought maybe it had to do with my brother since he was always getting into trouble, but then they brought up Halmea, and I thought, hey, I'll call her. You know, like we can like work out whatever it is, and that's when they told me that she had been shot, and that I was up for investigation.
And so, what action did you take? Any actions to get legal counsel after that?
I did. I sought an attorney, my attorney Freddie Sticks, who helped walk me through the first plea deal, which I didn't want to take at all.
How did he lay things out for you?
Yeah, why don't you ask the question, Parker?
Yeah, he laid out evidence that they had against me, and a lot of it seemed very like just coincidences from my perspective. So I wanted to keep fighting for the justice of like me and Halmea, and so we didn't take the first plea deal.
And so what happened after that?
After that, there was a second plea deal I got offered, which I again didn't want to take, but there was new evidence against me about an eyewitness who had supposedly seen me, and I felt like I could fight everything else, but this was definitely the last straw. I felt like everything was against me and that there was no way I could win.
Ultimately, even though that you knew that you weren't the person running away from the scene of the crime.
Could you repeat the question?
Yeah, Parker, I think you faded out, so why don't you repeat that question?
Yes, my apologies, Your Honor. So why did you ultimately choose in taking the second plea deal while with the knowledge that you knew that you weren't the person running from the scene of the crime?
The only reason why I took this second plea deal was because of the eyewitness. It was the only thing I knew I couldn't defend myself on, because they had word on me that I just couldn't defend.
Okay. Thank you for your time. No further questions, Your Honor.
All right, thank you. On behalf of the defense, cross-examination, or excuse me, the prosecution. Sorry about that.
Yes, Your Honor. May I proceed, Your Honor?
You may. Thank you for asking.
Good morning, Micah. I'm Carson Chaney, and I'm just going to be asking you a few questions on behalf of the state. You do have a criminal past, correct?
I definitely have had a few incidents with the law.
And when the police brought you in, you were initially nervous that it had something to do with your criminal past, right?
I mean, I was mostly worried about my brother, since I know that a lot of that trouble happened around me.
The police brought you in for questioning on September 3rd, correct?
I mean, that sounds about right. I'm not for sure, but yeah, that sounds right.
And this is when you said that you said this was when you first learned that Howman had been killed, correct?
It was, yes.
And you did mention in your statement that you felt scared when the police revealed this to you, right?
I mean, I felt a lot of things. Is one of them was definitely scare. I mean, someone got murdered, my best friend, for no reason. She was a saint. Of course I was scared. I didn't know what was happening. There was so much going on.
And you did have a troubled relationship with Howman, correct?
I mean, I don't think our whole relationship was troubled. We definitely had a rocky a part of our relationship.
At one point, you said that you weren't sure how you fit into Howman's life anymore, correct?
Yeah, yes, that's true.
And you weren't sure how Maya fit into your life either, were you?
I wasn't.
You said that Kai Robbins, who is Haumea's father, wasn't the biggest fan of you. And they didn't really want you around Haumea, did they?
I mean, from around the time I even met Haumea, I definitely felt like her dad had something against me, and it just got worse with age.
Well, would you agree that since you are twice convicted of drug possession and once of forgery, didn't help Kai Robbins' impression?
I mean, I definitely know that would have made it worse, but before that, he had no reason to dislike me, and I never felt welcome in their home once.
But this would be an excusable reason for them to, feel a disdain for you, correct?
I definitely think
Objection,
that
Your
would
Honor.
make.
One moment. Yeah, objection basis.
Relevance.
Counsel for prosecution, reply.
Under direct questioning, Micah was questioned about Kai Robbins. So I'm just responding to that.
On behalf of defense.
And Your Honor, while I believe that there was questioning pertaining to Kai Robbins, it was not to this degree, and therefore I don't see it to be relevant.
All right, I thank you for your arguments. I'll overrule the objection. I'll allow the question to remain at this time. And so I'll ask counsel to continue with your cross-examination. Thank you both.
So certainly,
Yes, Your Honor.
thank you, Your Honor. So back to where we were. Since you were twice convicted of drug possession and once of forgery, that would be a reasonable reason for Kai Robbins to feel a disdain for you, correct?
I mean, if her dad stopped liking me around that time, I totally would have get it. Like I perfectly understood. It was just the fact that like I had never felt like he liked me, and that wasn't. I mean, it didn't feel good. I mean, but I definitely, yeah, of course, I think that the other stuff totally makes sense.
Your Honor, may the record reflect that I'm presenting a clean and unmarked copy of Exhibit A. May I proceed with this?
You may.
Believe you guys should be able to see it now.
We can. I don't know if you want to do a full share. Well, I think everybody could see it.
Micah, can you see Exhibit A?
I can, yes.
Do you recognize this exhibit?
Unfortunately, I do.
And you yourself sent these messages to Hellman, correct?
Regrettably so.
Can you read
Yes.
aloud for us the second message on this page?
It says, "You're both liars and backstabbers, so it's really great you found each other."
Can you also read the final message on this page?
"I hope you both get the karma you deserve."
These messages can be characterized as threatening, correct?
I definitely don't think so. I don't know what part of this would, but it was just kind of a blow up moment. It definitely didn't mean anything though.
Can you read the fourth and final message aloud for us again, please?
"I hope you both get the karma you deserve."
Oxford Languages defines karma as destiny or fate, following as effect from cause. This means that you were wishing harm.
Objection, Your Honor.
Yeah, basis for the objection?
That was use of outside research beyond the information in the case packet.
Counsel for prosecution?
I believe that having a definition for a word doesn't fall under that specific rule.
May I respond?
Well, I'm going to find that it is outside of the scope of the mock trial. And so I'm going to sustain the objection. You may ask the question that you were driving to, but I'll exclude the definition that you found. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Motion to strike.
I'll strike his question, but you could re-ask in a different way, or you can continue your line of questioning, Counselor.
So given that one could easily define on their own that karma is essentially facing the consequences of your prior actions, would you agree that the fourth message in some way is threatening?
I mean, as a Buddhist myself, I think karma isn't up for the person to decide. And even though I said that in the moment, I mean, there's no one who can determine karma other than the universe itself. And so, I mean, it may have seemed threatening to someone else, but it was definitely just, I mean, Haumea knows me, you know, and I would never wish harm upon her. And so I was kind of just hoping that if what she did was truly wrong, that maybe she would at least feel regretful about it or would come talk to me about it. But I definitely didn't mean it to be threatening in any way.
You sent these messages on July 27th of 2019, correct?
Probably.
And you said in your statement that you loved Haumea and that you wanted her back as a friend. Is that why you sent these messages?
I sent these messages in a fit of emotion. I usually have a lot of outlets for expression, and I definitely didn't take time to cool down. So this was just me saying stuff I didn't mean. I did want her back as a friend, but this was obviously not the way to go about it.
And after this, you didn't talk to Haumea for around a month before her murder, correct?
Yes, that's true.
And on August 31st, which was the night of her murder, you met her in the food truck area where she was murdered, correct?
I mean, that's where we met. Yeah, that's where we planned to meet.
And after threatening Haumea, not speaking to them for a month, then suddenly asking to meet them, she was found dead where you met her, correct?
Yeah, she was. Yes, she was.
And you told me earlier that you had only learned that Haumea was dead when you went into the police that night. Well, on the to the police station on the night of September 3rd, correct?
Yes, that's true.
Counsel,
And also,
excuse me, are you still going to share screen for something next, or can we?
I can remove that, Your Honor.
Thank you, I appreciate that.
Thank you for that.
You're welcome.
Now we're better.
Thank you. You may continue.
Thank you. So about 4 days would have passed between the night of Haumea's murder and when you claimed to find out about it, right?
Yes, that's true.
And based on the evidence that the police had found, they later arrested you for Haumea's murder, correct?
They did.
And you didn't reach out to her at all. You didn't attempt to reach out to Haumea at all during those 4 days, did you?
Like I said, I wanted to give her space. I've known her for a really long time, and this was definitely a heavy topic that we both needed time to think on. So I didn't talk to her for a few days.
And after your arrest, your attorney, Freddie Sticks, requested a plea deal before you even knew of the evidence against you, correct?
I don't fully remember, to be honest.
And you were completely aware when you requested this plea deal that a plea of guilty, in fact, meant that you were admitting to killing Haumea, correct?
Based on what I heard from my attorney and the evidence and everything, yes, yes.
And you trusted your attorney, Freddie Sticks, correct?
At the time, I definitely did.
You say at the time, was there a time at which you didn't trust Freddie Sticks?
I mean, I don't trust a lot of people
Uh,
fully, completely.
Your Honor.
Yes, one moment. There's an objection, Parker.
Yeah, sorry, could the prosecution repeat the question? I was just fading out for a second.
Yeah, I appreciate that. So counsel, if you don't mind repeating your question, and then we'll have the answer.
Thank you,
Yeah.
Counselor.
Micah, you said that at the time you trusted Freddie Sticks. Was there in fact a time when you didn't trust Freddie Sticks?
I mean, I go in and out of trusting people just because I don't know. So I do trust Freddie almost completely, but there's definitely moments here and there where I have wondered. But I mean, I did put faith in my attorney at the time, yes.
And the initial plea was discussed before you knew the eyewitness identification, wasn't it?
Yes,
And then on October 15th, you pled guilty to killing Halmea Robbins, didn't you?
that sounds right, yes.
So you admitted to killing Halmea Robbins and waived your right to trial, didn't you?
I did.
And no one forced you to take this plea deal, did they?
I mean, no, not directly, obviously.
And you also knew that this meant that you would be convicted of voluntary manslaughter, didn't you?
Yes.
And you do claim to have doubts of the evidence against you, correct?
I did about the other coincidences, but the one that I definitely wasn't doubtful of was the eyewitness.
You didn't doubt the eyewitness testimony? You felt that
I was told that this eyewitness was strong, and so from my understanding of things, yeah, of course I thought that for whatever reason this eyewitness thought to have seen me there. And I just knew that, like, when you go in front of a bunch of people and say that you saw someone there, they're probably going to believe you more than the kid who has a bit of a rocky past.
And you said that you had confidence in your attorney, right? You trusted Freddie Sticks?
I did, yes.
But apparently you didn't feel it was necessary for your trusted attorney to argue your doubts in front of a court of law, did you?
That wasn't it at all. I just felt like, from what I understood, that this eyewitness was really pressing and that this was the only thing that would have changed the verdict.
You had doubts of the other evidence. You still could have had Freddie Sticks represent you in court over those too, though, correct?
I mean, of course, but those were like footprints and fibers, and everyone has those, you know. So I that was definitely something that I would put pretty much anyone of full trust in. Me myself, I didn't think that the one thing anyone could fight would be that eyewitness.
So, like I said, you didn't feel that it was necessary to argue these doubts before court, did you?
No, I didn't. I felt like it wouldn't work out.
So despite your claims of innocence, but your professed faith in the justice system, you admitted to killing Halmea Robbins and knowingly and voluntarily pled guilty, correct?
I mean, I guess so, yes.
No further questions, Your Honor.
Thank you. Cross-examination or excuse me, redirect on those questions, please.
Yes, Your Honor. So, Micah, can you just explain again why you chose to take that second plea deal? You knew that it wasn't you running away from the scene of the crime.
It was because of the eyewitness, solely because of that eyewitness. If that hadn't been a part of it, I would have continued to fight for the justice of myself and for Halmea's murder.
Okay, no further questions, Your Honor. Thank you.
Thank you. Any recross on that question?
Yes, Your Honor.
You may proceed.
So you just mentioned the eyewitness testimony. You weren't aware of that when you entered the first plea negotiation, correct?
Yes.
No further questions, Your Honor.
All right, thank you. All right, the witness may step down and we'll ask defense if they'd like to call their second witness at this time.
Yes, Your Honor. The defense would like to call Ms. Charlie Nguyen to the stand.
All right. I'll note for the record that this witness has been sworn in, and so I'll remind the witness of that, and we can begin your direct examination. Thank you.
Thank you, Your Honor. Hello, Ms. Nguyen. Thank you so much for being here today. Could you please state your name and occupation for the record?
Certainly. My name is Charlie Nguyen, and I have been a licensed private investigator for 10 years now. And before that, I was with the Buckeye PD for 15 years, and I've worked on over 100 cases.
Thank you, Ms. Nguyen. Could you please explain your time more at the Buckeye PD?
Certainly. So I spent most of my time there as patrol officer. And after I felt like I had used a lot of my skills and I wanted to do more for the community, I decided to become a detective, and I took a bunch of classes to do so.
What were these classes on?
Well, these classes were on criminal investigations, evidence analyzation and collection, DNA collection. I learned how to interview eyewitnesses and suspects. And after all of this training, I was able to become a certified evidence technician with the Buckeye Police Department.
Your Honor, the defense would like to tender Ms. Charlie Nguyen as an expert witness in the field of forensic evidence and investigation.
And thank you. Is there any objection from the prosecution?
No, Your Honor.
All right, thank you. Then you may inquire. I'll qualify this witness as an expert in that area of law.
Thank you, Your Honor. Ms. Nguyen, can you please explain your relation to this case?
Certainly. I was brought on by investigator Freddie Sticks to take a deeper dive into the evidence, as well as look into the eyewitness testimony. And as this is pretty typical for attorneys to hire private investigators, that's how I was brought on in this case.
Could you explain what physical evidence was found at the crime scene pertaining to this case?
Certainly. So there were a couple pieces of physical evidence at the scene. Some blue nylon fibers found on the victim, Humea Robbins, as well as a partial fingerprint on the glasses of Humea Robbins and a footprint from motor oil on the pavement, as well as an eyewitness.
Go ahead, Ms. Nguyen.
Testimony identifying Micah Opusea as the person they saw fleeing the scene.
Perfect. Thank you, Ms. Nguyen. I would now like to focus on each piece of evidence individually, starting with the eyewitness. Were you at any point in contact with Corey Abrams, who is the eyewitness?
Yeah, so I attempted to contact Corey Abrams, but unfortunately they were at a food truck convention for 10 days, so I wasn't able to meet with them in person. I decided to give them a phone call. They didn't pick up, so I left a voicemail saying that I was a private investigator, but I didn't want to mention anything else, as I didn't want to taint their recollection. I asked them to call me back, but unfortunately they never did. And I didn't want to call them more times, and I didn't want to badger this witness.
Thank you for that explanation. Now I would like to turn the court's attention and your attention to the partial fingerprint. Let the record reflect, I am prompting my co-counsel to screen share a clean and unmarked copy of Exhibit D. If you can just give us one moment, Your Honor.
Sure.
Perfect. Thank you. Ms. Nguyen, could you please describe box A for the court?
Certainly. So box A depicts the partial fingerprint lifted from the victim's glasses.
And could you please describe what is depicted in box B for the court?
Box B shows the comparison print. In this case, it's Micah Opusea's.
And finally, could you please describe what is depicted in the bottommost box?
So in the bottommost box, you see the partial fingerprint laid over Micah Opusea's print, where you can clearly see the only 7 points of identification between the two prints.
Thank you. Could you please explain how fingerprint identification works?
Certainly. So fingerprint identification works by matching points. It's simple as that. There are 3 different types of fingerprints: loops, swirls, and arches. And these never change over the course of a person's lifetime.
And to your knowledge, how was this fingerprint identified?
This fingerprint was identified by the 7 points of identification between Micah Opusea's print and the partial fingerprint on the victim's glasses, it honestly surprised me that these two prints were considered a match.
Why were you surprised these fingerprints were considered a match?
Well, in my line of work, and at the places that I have worked, I have always learned about the 12-point standard that is required to identify matching prints. I learned this in my classes that I took, that we should usually go with a 12-point standard. Considering there are over 150 points in a fingerprint, 12 is still pretty low, and I was surprised that the second examiner would have let this through with only 7.
Why would a second verification be important?
Well, this verification step is extremely crucial to identifying and matching fingerprints because the fingerprint identification process is so subjective. I believe that Micah never would have been identified had there been a second examiner, and as that information is missing from the report, I don't know if there was.
Thank you, Ms. Swin. I would now like to turn your attention to the footprint that was found at the scene. Let the record reflect I'm prompting my co-counsel to screen share a clean and unmarked copy of Exhibit E. Thank you. Ms. Swin, could you please describe what is depicted in this image?
Certainly. So this image shows the footprint on the scene from motor oil next to a ruler showing the size.
Could you please tell the court what type of footprint this is?
Yeah, so there are 3 different types of footprints: visible, plastic, and latent. In this picture, we have a visible print, which is a print that can be seen with the naked eye without the help of any additional aids. Our print is the result of someone stepping in motor oil and then essentially staining the pavement next to it. It's hard to identify exactly when it got there, as oil stays on the pavement for a very long time.
And where was this footprint found?
This footprint was found on the pavement near where Humea Robin's body was found.
And what was the size and make of this footprint?
Well, the size and make of this footprint was identified to be a size 9 pair of Converse, but as I'm not sure what angle the photograph was taken at, I'm not sure if it is a size 9 pair of Converse, because the photo must be taken at exactly a 90-degree angle to get an accurate depiction of size, because the difference in shoe size is so minimal.
Thank you, Ms. Nguyen. I would now like to turn the course of discussion towards the blue nylon fibers found at the scene. My co-counsel can now stop sharing his screen. Perfect. Could you please explain where these nylon fibers were found?
Certainly. So these nylon fibers there were a couple blue nylon fibers found on the victim, Humea Robbins.
And can you just describe more what these nylon fibers were?
Yeah, so nylon is a very common material, and these blue nylon fibers could have been transferred to the victim, Humea Robbins, from anything as simple as a hug or a brush against them, the blue nylon fibers are fairly common materials, so I wasn't very surprised that they were found on the victim at all, considering how common of a material it is.
If the material is so common, then how were these fibers matched to Micah?
Well, these fibers were matched to Micah because Micah was wearing a blue nylon bomber jacket, but I can't conclusively say that these fibers belong to Micah's jacket, considering how common the fibers are.
Thank you, Ms. Nguyen. I just have one final question at the moment. In your expert opinion, given all that you have shared today, is there any way that this evidence can conclusively incriminate any person?
I would say that it cannot be. It's important to remember there's no way to tell when any of this evidence actually got there. If you look at the fingerprint, it could have been from Micah picking up Humea's glasses for them at any point. And there's no way to tell when that got there, considering how, there's no way to tell when that got there. If you look at the footprint, size 9, even if that footprint did belong to Micah's size 9 Converse, there's no way to tell when that got there, as oil stays on the pavement for a very, very long time. It could have been the day of the murder or a week before. We just don't know. And then if you look at the nylon fibers, those could have come from anything as simple as any physical contact or a hug to Humea. And it's important to remember that there was no murder weapon found at the scene. So there's no way to tie a murder weapon to Micah. In my opinion, there's no way to tell that this evidence is not conclusive enough to incriminate any person on its own.
Thank you, Ms. Nguyen. No further questions at this time, Your Honor.
All right, thank you. We'll have our timers reset the clocks for both of you, and we'll go ahead and have cross-examination. Thank you.
Thank you, Your Honor. So, Ms. Nguyen, the fingerprint that was found on Humea's glasses was an arch type, right?
Yeah, so the fingerprint found on Humea's glasses was an arch type along with 7% of Buckeye's population, which if you look at the population, it comes out to be 812,000 people, which is certainly a lot. It's not 7 people, it's 812,000.
But you say that number, 812,000. That's accounting for the entire state of Buckeye, right?
Yeah, if you look at the population of Buckeye is 11.6 million, and the percentage that has arch prints is 812,000. So that's still a very substantial number. It's not one person on the street.
If that 812,000 is for the state of Buckeye, wouldn't you agree that if it's just including the city of Harmony, it would be much, much smaller of a population?
I mean, a city is smaller than the state itself, so yes, it would be a smaller number, but that's still a substantial amount of people. I don't have that number available, unfortunately.
And Michael Passay is known to have an arch type print, correct?
Yeah, that's correct.
And with only a small portion of the fingerprint, you were still able to find more than half a dozen matching points, right?
So I wasn't the one examining the fingerprint originally, but the examiners did find only 7-point identification when my standard and the standard that I learned in my classes and in my experience has always been at the very minimum 12, which is almost double.
Your Honor, could you please excuse me? I have something to deal with because there may be some background noise. So if you would please ask the timekeepers to stop time for a small portion, I will be right back.
Sure. Okay. So we'll pause the time for a moment. And I do have to ask the two timers. So you guys have been off by
Yeah,
why-
there have been a few discrepancies between direct and cross-examination. I am having a bit of internet issues, so that may be why. I paused the timer whenever I thought the attorney's internet was having a problem, but it may be because of my own.
Okay. All right. So
Thank you, Your Honor. Sorry for the interruption.
And that's fine, Mr. Jones. I was talking to the timer. So thank you, Ms. Becker, for explaining that. I mean, at some time I could see there's discrepancies, but I'm keeping, time here too. I don't find it's a discrepancy that's caused an error at any point in time. So thank you for telling me how you were handling that when your timer. Okay. So we'll go back on the record. Our timers will start, and then Mr. Jones, you may continue.
Thank you, Your Honor. So, was those 7 points of matching able to give a strong correlation to the defendant?
Sorry, could you rephrase the question? I didn't really understand.
Let me rephrase. Were the seven points of connection between the fingerprint on Humea's glasses and Michael Passay's fingerprint was enough to give the correlation to him, correct?
I assume the detective on scene and the evidence technicians did identify the print as Micah's because of the 7 points, but as with my with all of my experience in mind and how I've always done fingerprint identifications, I would have never considered it a match.
And in direct, you stated that you usually use a 12-point standard, right?
Yeah, that's the standard that I learned in all my classes as well as in my previous experience.
But is it true that there really isn't a true standard that is followed by everyone?
It's true that there is no government or official standard, but that's the standard I've always used.
One of the other pieces of evidence you looked over was the shoe print in the parking lot, correct?
That's correct.
And according to the discovery, it was plainly a size 9 Converse sneaker, correct?
It was identified as a size 9 Converse, but as the angle of the photo that it was taken at is missing from the report, I'm not sure if that's 100% accurate.
And it is true that Micah not only owns, but also wears several pairs of size 9 Converse, right?
Yeah, along with myself, I own, I think, 5 pairs of Converse. And I know many people that wear a size 9 but Micah is one of those people, and that's correct.
Would you agree that it's pretty likely that the shoe print appeared there in that parking lot the night of the murder?
Objection, Your Honor.
Basis? Ms.
Lack
Woods?
of personal knowledge. Ms. Nguyen would have no way of knowing when the footprint was placed there.
Mr. Jones?
I am simply asking for Ms. Nguyen's expert opinion on whether it's likely that the shoe print was there.
I'll allow if you can answer the question under your expert opinion, whether you know that answer or not.
Thank you, Your Honor.
Thank
Yeah,
you.
so based on what I had discovered, what I know about oil, and with my experience in this type of area, there's no way to know when that shoe print got there, considering oil stays on the pavement for a very long time, and it's very difficult to wash away with rain.
You say it's difficult to wash away in rain, but would you still stand by that statement even though it had been raining in Harmony for several days, even into the night of the murder?
I'm not aware exactly how long it was raining or what amount, but I am still certain that oil can stay on the pavement even in the event of rain.
I'll move on to another piece of evidence. The blue nylon fibers was another piece that you looked at, right?
Yeah, that's correct.
And those blue nylon fibers were consistent with the type and color of the blue bomber jacket worn by Micah Opusay that night, correct?
Yeah, along with countless articles of clothing worn in Harmony every day, blue nylon was the fabric of Micah Opusay's bomber jacket.
You would say that the eyewitness testimony was very important to this case, correct?
I would say that the eyewitness testimony was a considerable factor in this case. That's correct.
So even considering, in your opinion, the importance of the eyewitness testimony in this case, you only tried to contact him once, correct?
Objection, Your Honor.
So we're out of time, but I'll hear the objection.
Thank you, Your Honor. My objection is on my witness is an expert in the field of forensic evidence and investigation, not in the criminal proceedings within the court. So my Charlie Nguyen would have no knowledge on whether or not it would be an importance to the case.
Mr. Jones?
I was simply asking that because Ms. Nguyen both reviewed all of the evidence in question in the discovery and also was paid to look over the case as well as they could, I'm merely asking for what they had thought in one individual piece of evidence.
So
Your Honor, may I respond?
Well, let me do this. I'm going to overrule and let her answer it if she can. So I'll let the witness answer this question and then we'll conclude based on our time. So go ahead and answer the question if you can.
Thank you, Your Honor.
I would say that when you're looking at an eyewitness, it can be substantially important that an eyewitness identification is part of the case itself, but I would not say it is the only important factor.
All right, thank you. So at this time, I'll go to examination for counsel for the defense. Any redirect based on the questions asked by Mr. Jones?
Yes, Your Honor, just one question.
Go right ahead.
Ms. Nguyen, can you just explain one more time, why do you follow a 12-point standard?
Yeah, so I follow a 12-point standard because that is what I was taught in my classes that I talked about in the very beginning of my direct examination with my DNA collection and analysis, as well as I took specific classes on fingerprint identification. In these classes, I learned about the 12-point standard. And then when I was working as a detective in the Buckeye Police Department, the evidence technician that I worked under always followed the same 12-point standard. And so I continue to do so in my own practice.
Thank you. Thank you, Ms. Nguyen. No further questions, Your Honor.
Mr. Jones, any thoughts on that question?
No, Your Honor.
All right, thank you. We'll allow this witness to step down. On behalf of the defense, any further witnesses?
No, Your Honor. The defense rests.
All right, thank you. On behalf of prosecution, if the prosecution would like to call their first witness, I believe you've identified Robbins and Foley as your two witnesses.
That is correct, Your Honor. We would like to call Mr. Kai Robbins to the stand.
Very good. I'll remind Robbins that you're under oath at this time, and I'll allow the questions to be asked, and please keep your voice up. Thank you.
May I proceed, Your Honor?
You may.
Thank you. Good morning, sir. Can you please state your name for us?
My name is Kai Robbins.
And do you know why we're here today?
Yes. Mike Opuse is trying to get off the hook for taking away everything that he took, from my family.
And what can you yourself tell me about Mike Opuse?
Mike Opuse is the convicted killer of my daughter.
I'd like to apologize in advance for any thoughts or feelings that today's proceedings may bring back to you. How did your daughter know Mike Opuse?
Thank you. And they were friends. She was gracious and kind, and Micah was lucky enough to be called one of her friends, although I'm not sure Micah could say the same.
What about your daughter? Would you mind just describing her for us a little bit more, just a little more in depth?
She was kind-hearted and loving.
Objection, Your Honor. Relevance.
Counsel, reply.
Your Honor, I am laying foundation for future questions.
I'll allow
Your Honor,
this.
may I respond?
Well, it is direct examination, so let's. I'm going to allow some leeway here with this line of questioning. So I'll overrule, but go ahead. Direct examination. I'll allow you to continue to inquire.
Okay, thank you, Your Honor.
Yeah, thank you.
Thank you, Your Honor. So going back to that, would you mind describing your daughter for us?
My Homea was kind-hearted and loving. And when I look at myself, I see bits and pieces of her. And it strikes me in all my years of life, I could never and was never as wonderful as she was.
And how would you describe your parenting style?
Very hands-on. I tried to be as helpful as possible. And whenever she came to me advice, I'd give it to her. Whenever her friends were over, I would always make snacks for them and help with homework problems.
And were you yourself at all involved in her social life?
Almost definitely. I consider us best friends.
And so how long had Homea been friends with Mike Opuse?
Oh, it's been a while. I remember Homea welcoming Micah as a best friend.
And so which of your daughter's friends were around your house the most often?
It was majority of the three of them. It would have been my Homea, Scout Farad, and Micah Opuse.
And so between the three of them, how would you describe the dynamic?
They were all friends, of course, but as time went on and they developed into young adults, Homea and Scout had started dating. Micah became the third wheel.
So at the time, were you aware that Scout and Homea were dating?
Well, yeah, she came to me with advice. She asked my opinion and I told her to follow her heart. In the end, she picked Scout.
How would you describe Micah's behavior in the weeks and months leading up to her murder, to Homea's murder?
Micah exhibited concerning behavior. I mean, it was suspicious. It worried me. I feared that he'd been manipulative or deceptive whenever he was straight up mean to Homea.
And do any specific incidents or moments stand out in this time frame to you?
Yes, one night in particular, the three of them were over at our house. I was minding my own business in my kitchen when I heard things getting restless in the other room. Before I made my way over there, I heard Micah shout, "You're gonna pay for treating me like this."
So what did he do following this?
He stormed out of my house.
I'd like to come back to what you said earlier. You said that Michael was acting like a third wheel. Can you provide us some more information about this?
Obviously, he wanted a relationship with my daughter. Micah never got that. So, I mean, it was obvious to us.
Objection, Your Honor, lack of personal knowledge.
Response?
Your Honor, Mr. Robbins is just relaying his perception of events.
Ms. Woods?
Your Honor, yes, Your Honor. There's no way that this witness would have any idea the feelings and thoughts of Micah Opusay. Therefore, they cannot make a statement on how Micah was feeling at the time.
You know, I'll sustain the objection. You can rephrase your question if you want to get further into this discussion, but I'm going to strike the response and ask that you ask your next question.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
And so in your statement, you said that Micah was sort of harassing Omar. How was he doing this?
Both publicly and privately, through a stream of social media posts and private text messages.
Your Honors, I would like to present a clean and unmarked copy of Exhibit B to Mr. Robbins. May I proceed with this?
You may. And you're going to share that with us as well?
Yes, I am.
Thank you.
Okay. Can you tell us what these are? Or Exhibit B? There we go. Can you tell us what these are?
These are social media posts posted by Micah Opusay.
And would you mind reading them aloud for us?
Yes. Starting with the ones on the left. Your innocence was cute once until I learned you were lying on all fronts. I let you take advantage because I thought you were just damaged. You think you would have learned I'm not one to sit around and be burned. I'm not passive, just aggressive. Maybe it's time to get the message. Heard whispers in the hall, you two are starting to fall. But you forgot one thing. What about my suffering? It was us who locked eyes first, and my heart felt at my first. Who knew that down the road my friend would become my foe? Betrayed in the worst way. I told you there that day. I thought we were meant to be, then you took them away from me.
Mr. Robbins, from your perspective, what do these posts contain?
Objection, Your Honor, improper character evidence.
Counsel for prosecution?
Your Honor, I am just attempting to have Mr. Robbins explain how he views these tweets.
Any
Your Honor,
response?
may I respond?
Yeah.
Yes, Your Honor. The only evidence that Kai Robbins ever interacted with was the text messages. Kai Robbins, according to their witness statement, would have no knowledge of these poems and therefore cannot comment on the poems.
And so counsel for the prosecution, I do see that in the deposition statements I have before me. And so I'm going to sustain the objection. I'll allow the witness to read this, and then I'll ask that you move to your next line of questioning.
Thank you, Your Honor.
Thank you, Your Honor. Motion to strike.
Yes, and strike for the record, and I'll ask that he move on to his next line of questioning. Thank you.
Thank you, Your Honor.
So I would like to now present a copy of Exhibit A to Mr. Robbins. May I proceed?
You may. Thank you.
Do you know what these are?
Yes, this is a screenshot of the messages Micah had sent to Homer.
And how did you yourself learn about these messages?
Scout had shown them to me.
So can you just go ahead and read through them for us?
Super cool that you're spending so much time with Scout. You two are really perfect for each other. You're both liars and backstabbers, so it's really great we found each other. Just do me a favor and keep my name out of your mouth from now on. I hope you both get the karma you deserve.
Do you know what you just read for us?
These are the text messages that Micah had sent to me.
And are you aware of the date that Hamaya received these messages?
As I know now, these messages were sent on July 27th.
So given the substance of these messages, how do you view the final message, the fourth one?
Objection, Your Honor, speculation.
Counsel for prosecution? Casey?
I asked for my witness's perspective of it, and he is entitled to such.
Ms.
Your
Woods,
Honor,
any-
may I respond?
Sure.
Yes. I mean, the question very explicitly said, what do you think of the last text message? And that is the definition of speculation. The question is asking for the witness to speculate on the reasoning, the meaning behind the text message.
Well, at this time, I'm going to overrule the objection, and I'm going to allow the witness to give, if he could, a statement on what he believes. I hope you both get the karma you deserve. So I'll allow his opinion at this time.
Thank you,
Thank you,
Your
Your
Honor.
Honor.
Thank you both. You can answer the question, sir.
So how do you view these messages, this last message from your perspective?
Well, this last message, I hope you both get the karma you deserve. Obviously, the word karma sticks out. It sticks out. That's the biggest word I see. When I think of karma, I obviously think of someone's fate being determined by their actions. I know that my Hamea rejected Micah. Micah was not happy about this, as he's shown in these text messages. And that's what I see. I see them as a clear threat directed towards my daughter.
And you said that Scout showed you these messages. Why didn't Hamaya show them to you?
I trusted Hamea. And as she might have been scared or for whatever reason, I trusted her. And she would have done as any kid would have done at that time.
Now, what can you tell me about Hamaya's glasses?
Hamea had this habit where if she was ever nervous or scared, she would excessively clean her glasses.
And
Counsel,
is there any-
Counsel, excuse me, do you want to stop sharing your screen?
yes.
Thank you.
And was there any change in the frequency of this behavior around the time of the murder?
I had noticed about late summer, so it would have been end of July, early August, that Hamea had started cleaning her glasses over and over again.
And can you tell us again when Micah sent Hamaya the messages that you characterized as threatening?
It would have been July 27th, which means Hamea had started cleaning her glasses whenever Micah had sent her these messages.
And so, as Hamaya's parent, what did this mean to you?
Hamea was scared. She was afraid. I mean, that's the only thing that makes sense whenever it comes to her glasses, because she only cleaned them whenever she was scared.
Thank you, Mr. Robbins. Your Honor, that will be all.
All right, thank you. I'll have cross-examination.
Yes, Your Honor. Hello, Mr. Robbins. My name is Isabella Wood, and I will be your cross attorney today. If at any time you'd like me to restate or rephrase a question, let me know and I'll be happy to do so. And of course, I understand that this topic we are dealing with is very difficult, so if at any point you need a break, please let me know. I am so sorry for your loss.
Thank you.
Mr. Robbins, you've stated that your daughter Hamea told you everything, and then on direct you stated how you trusted Hamea, correct?
Hamea and I were best friends. We had a trustworthy relationship, and yes, of course I trusted her.
And your daughter told you everything?
Yes.
So on the night of August 31st, 2019, did Hamea tell you she was leaving to go meet Micah?
I recall
Objection, Your Honor.
Your basis,
The question calls for hearsay.
Ms. Woods?
Your Honor, may I respond?
Sure.
The question itself is merely asking the interaction he had with his daughter. It does not ask for anything on he said, she said, for the truth of the matter asserted.
Yeah, so I'm going to overrule the objection and allow the witness to testify to his own interaction with his daughter, if he can recall. So why don't you ask that question again? And thank you both.
Thank you, Your Honor.
Thank you, Your Honor. Mr. Robbins, on the night of August 31st, 2019, did Hamea tell you she was leaving to go meet Micah?
That would have been the night that she was murdered. She told me that, well, actually, what happened was Scout was over at our house. They both got hungry, so Hamea went to go get food.
But Hamea did not tell you that she was going to go meet Micah, correct?
She had told me that that she was going to go get food.
So that is a no to my question.
No.
Thank you. Were you aware of the text messages that Micah had sent Hamea, the ones that you later turned into the police, prior to Scout Farrat showing them to you?
I became aware of the text messages once Scout had shown me them. Scout had shown me them after it had been taking Hamea a while to get back from getting food from the food truck.
So, but prior to Scout showing these text messages to you, you were not aware of them?
I did not have prior knowledge, no.
Thank you. Mr. Robbins, I'd now like to focus more on the night of Hamea's death, August 31st, 2019. Just before 7 p.m. that night, Hamea told you she was going to get food from her favorite food truck up the street, correct?
That is correct.
Did you go with her to get said food?
I did not.
Were you present when Hamea had her meeting with Micah?
I did not.
Did you see Micah kill Hamea?
No, I did not.
Were you the one to find Hamea's body?
I was not.
Were you ever part of collecting the evidence found at the crime scene?
I believe that's not my job, no.
Were you ever at any point a part of the evidence matching process?
Objection, Your Honor.
Basis?
Relevancy.
Counsel, Ms. Woods?
Your Honor, this question is very relevant as it calls to question the legitimacy and the importance of this witness.
Well, but if he can answer the question, I believe your question has to do with investigative work. And so why don't you ask that question again? And I'll hear his answer. So I'll overrule and go ahead and ask that question. Thank you.
Thank you, Your Honor. Mr. Robbins, were you ever at any point a part of the evidence matching process?
I don't think I'm able to do that. I'm not qualified for that work.
Thank you. Were you ever able to be in contact with or examine the evidence found aside from the text messages?
Aside from the text messages, that's the analytics. I can't help with any of that.
Thank you. And are you at all professionally trained in the field of forensic evidence identification and or criminal proceedings?
Sorry, please restate that question.
Do you at all work in the field or are you professionally trained in the field of forensic evidence identification or criminal proceedings?
No.
But you say you knew it was Micah who killed Hamea?
Micah had shown previous threats directed towards my daughter, as he did multiple times.
But you have stated that you knew it was Micah who killed Hamea.
It makes perfect sense.
Thank you, Your Honor. Thank you, Mr. Robbins. No further question, Your Honor.
Thank you. Any redirect, counsel, with respect to those few questions?
Yes, Your Honor.
You may proceed. Thank you.
Thank you, Your Honor. So, were you aware that there was a court case involving Michael Epstein?
I had no knowledge, no.
But were you aware that Micah had testified guilty?
Objection, Your Honor, outside the scope of cross.
Yeah, and I'll sustain. So there were no questions asked of the trial or what happened at the trial of this witness. So I'll allow you to continue to ask, and I'll sustain that question.
Your Honor, I was speaking.
Thank you, Your Honor. Motion to strike.
One moment. Go ahead. I'll hear Casey.
I was speaking in reference to when my witness was asked how they knew that Micah had done it.
So you're going to that statement that, and then you want to bring in the trial? Is that how you're going to present that answer?
Yes, I was attempting to.
Why don't you, I'll sustain the first question. Why don't you go ahead and rephrase it in a way that the court will allow it to come in as redirect?
Thank you, Your Honor. Motion to strike.
Yeah, I'll strike, but go ahead and rephrase the question to get your answer.
Thank you, Your Honor. So well, I guess, how do you know that Micah did it?
I am well aware of Micah's criminal past, Micah's concerning behavior on all fronts. I mean, I was very, very aware of all of that as my daughter. When it comes to the trial, all I know is Micah pleaded guilty to killing my daughter.
No further questions, Your Honor.
And then any recross on those questions?
Yes, Your Honor, just one. Mr. Robbins, did you see Micah kill Hamea?
I did not see the killer, no.
Thank you. No further questions, Your Honor.
All right, thank you. You may step down, sir, and thank you for your testimony. Prosecution, if you want to call your last witness, Mr. Foley.
Yes, Your Honor.
I'll remind this witness that he's under oath, and then you may inquire at this time. Thank you.
Please state your name for the record.
River Foley.
Let's learn a little bit about you. So what's your occupation?
I'm a police officer at the Harmony Police Department.
How long have you worked as a law enforcement officer?
I have been working as a law enforcement officer for the past 24 years. I was hired in November of 1996.
What experience did you gain in your time as a law enforcement officer?
I attended state investigator training in 2000. I completed over 300 hours of training, and I received the prestigious Master Evidence Technician Award in 2002. I was promoted to my role as detective in May of 2003.
How many cases have you worked on as detective?
I worked on over 400 cases, serving as the lead detective in over a dozen.
What additional training have you received in this field?
I completed 4 months of advanced criminology training. I gained extensive knowledge about bloodstains, fingerprints, shoe prints, fibers, death investigation, and crime scene photography.
Your Honor, at this time, the prosecution moves to admit this witness as an expert in the field of forensic evidence and science, specifically including the areas of fingerprint, blood sample, shoe print, and fiber evidence due to their established specialized knowledge, skill, experience, training, and education in those fields.
Could the prosecution just restate that what the expert was being tendered under?
Under forensic evidence and science, specifically including the areas of fingerprint, blood sample, shoe print, and fiber evidence.
Thank you. No objections.
How did you become familiar with the Hamea Robbins murder case?
I was involved since the beginning. I was one of the officers that was responding to the call on the night of August 31st, around 8:30 p.m.
Where did you go?
It was on the corner of First and Green and popular Harmony food truck location.
What was the first thing you did when you arrived at the scene?
I noticed one of the owner-operators of the food truck, Corey Abrams, was nearby, and I went over to have a conversation with them to see if they had any important information I could learn.
What did your conversation with Corey Abrams reveal?
They told me that they had seen somebody running away from the scene carrying a gun. I got a description of their face from them and noted it, and then I went over to the scene.
What do you do after your conversation with Corey Abrams?
I talked with one of the crime scene investigators and noted all the evidence we've collected.
What did you learn from the evidence that had been collected?
We had a partial fingerprint from the victim's glasses. We had fibers on the fibers. We had blood stains, and we had multiple shoe prints.
What did you know about the timeline of evidence?
It had been quite rainy in Harmony, even into the day of the crime. Rain usually works against the crime scenes, but in this case, it helped us. The rain washed away the other stuff, so we had a high degree of confidence that all of the stuff at the crime scene was placed there shortly before or during the murder.
What was the next step in the forensic process?
We had to get everything processed by the lab, but due to Labor Day, the lab was on a backlog until September 3rd.
What did you learn after the evidence had been processed?
Nothing too much, but we learned that the fingerprint was an arch type, the rarest type.
Your Honor, may the record reflect I am presenting clean and unmarked copies of Exhibits D and E. Could you please turn your attention to Exhibit D? I'm going to need someone on my prosecuting team to present those. Thank you. May I proceed? Sir Russo, you appear to be muted.
And I said, go ahead. I'm sorry. Thank you.
Thank you. Are you familiar with this exhibit?
Yes, this is the print on record for Micah Osei comparing to the print pulled from the victim's glasses.
Could you describe what the analysis shows?
It shows 7 points of high confidence matching and a high degree of confidence that the print from the victim's glasses is Micah Osei's print.
What did you think of the importance of this evidence?
It was important, but I also wanted to make sure I wanted to also look at all the other evidence.
How did that affect your view of the case?
I've known Micah, she had been involved with a forgery. She had also been booked for possession of marijuana, and that's what led to her having the fingerprint and input into our system.
Could you please turn your attention to Exhibit E? Do you recognize this exhibit?
Yes, this is the shoe print found at the scene of the crime. It matched a size 9 Converse sneaker.
Were there any other pieces of physical evidence you reviewed?
There was blue fibers. After the lab process them, we found that they were blue nylon fibers from a bomber jacket.
How did this evidence connect to the crime?
Corey Abrams the eyewitness Corey Abrams said that the person they saw fleeing the scene was wearing a blue bomber jacket, and then there was also another food truck owner who had confirmed that they had somebody wearing a blue bomber jacket and Converse sneakers purchased food at their truck.
How did you proceed after these revelations?
Mike was definitely a person of interest at this point, but I wanted to make sure that I was looking at everything. So I continue to investigate.
What did you learn about Mike up to that point?
Well, I did some research on Micah, and I wanted to bring them in for questioning.
Your Honor, may the record reflect I'm presenting clean and unmarked copies of Exhibit B. Could you please turn your attention to Exhibit B?
Thank you. It'll be noted that it's being shared on the screen. Exhibit B is in boy.
Could you please read the final 2 lines of Mike Opusay's tweet from August 9th?
I'm not passive, just aggressive. Maybe it's time you get the message.
How did this quote affect your investigation?
It seemed Micah was trying to seem tough, and this elevated my suspicion.
Objection.
And basis for your objection?
That would be improper opinion.
Counsel for the state, any reply?
I am merely asking for the Mr. Foley's opinion on this specific piece of evidence as he did review it, and I will be asking further questions about it to him later.
May I respond, Your Honor?
Yes.
Your Honor, the witness was specifically tendered in forensic science as well as the specified tangible pieces of evidence, and nowhere were they tendered as an expert in analyzing the psychology and characteristics of social media posts.
So I'm looking at the question. I'll allow him to answer it, but not in an expert opinion. I don't believe he was asked to do that other than to give his opinion based from his experience as a detective. So I'll allow him, if he could, state, again, you'll get a chance to cross him and confront some of those other questions you might have. So you could go ahead and answer the question.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Could you repeat the question?
Yeah, Mr. Jones, can you repeat that?
How did this quote affect your investigation?
It seemed that Micah was trying to act tough, and this elevated my suspicion.
What did you do because of this elevated suspicion?
Well, I did some online research. I did some more online research, and I eventually brought her in for questioning.
What did you learn during your questioning of Micah?
I first focused about the whereabouts of her at the time of murder, and that's when I found out that she was wearing clothing items that matched the description given by Corey Abrams.
Did anything in particular stand out to you during this questioning?
Yes. When I was asking questions about Scout and Hame's relationship, Micah became visibly irritated with the questions I was asking.
Could you tell us why this stood out to you?
This stood out to me because it seemed that Micah was very passionate about Hame, and this definitely gave him more motive.
From your experience, how did this affect your perception of the case?
Well, I've seen many cases involving love triangles and jealousy, and it just gave Micah more motive. But I also wanted to look at everything else along with it, so I continued to investigate.
What was your next step?
Since we had an eyewitness, I wanted to bring them in for a photo lineup. But with Corey Abrams being out of town for a convention, that delayed our meeting by a couple days. But I was eventually able to bring them in for a photo lineup.
How did you conduct this photo lineup?
Counsel, excuse me, do you still want to share their screen, or do you want to go back to?
No.
If you can have your co-counsel move that. Thank you. All right, go
May
ahead
I
with
proceed?
that. Yes.
How did you conduct this photo lineup?
I gathered 5 photos of that matched the description given by Corey Abrams, and I had them pick who they saw fleeing the scene at the night.
What was the result of this photo lineup?
The result was Corey Abrams identified Micah Opuse as the person they saw fleeing the scene.
How did this identification affect the case?
It affected the case by backing up what we already knew. With all the evidence pointing to Micah, this just added on to it.
What happened next?
After that, I obtained the arrest warrant for Micah, and we brought him into custody. He was given a trial date, and the standard prosecution procedures were followed.
Did anything of significance happen after you made the arrest?
Yes. On October 6th, Corey Abrams contacted me and told me that they were now unsure of their initial identification of Micah Opuse. I didn't think much of it, just as like an overreaction to some news feeds. But since I wanted Justice Oakmore to be ready, I told them of Corey Abrams' reservations. They acknowledged me, and it was out of my hands.
Did you have any further experiences with the case?
And for the record, time has ended, but I'll allow this question to be answered. Go ahead and answer the last question.
I heard Micah took a plea deal, and I figured that was the end of it until I was notified I would be testifying here today.
All right,
Thank you, Your Honor. No further questions.
Thank you. Cross-examination?
Yes, Your Honor. Okay, before I start questioning, I just want to remind you for the clarity of the courts that Micah uses they, them pronouns. So just try and be conscious of that in your answers. So I just want to start with your background. You said you were a detective for, it was 24 years?
I got promoted to detective in May of 2003.
And you also received a Master Evidence Technician Award. Is that correct?
Yes.
Okay. So I want to talk about the night of the murder. You said you arrived at the scene shortly after 8:30, or was it 8 p.m.?
Yeah, around 8:30.
Okay. Right. And upon arriving, you talked to Corey Abrams.
Yes.
So when you were the lead detective on this case?
Yes, I was.
Okay. And during that time while you were talking, you also said that there was a criminal science investigation officer that was collecting evidence. Is that correct?
Yeah, there was a crime scene investigator that was collecting the evidence.
And that was going on while you were talking to Corey Abrams?
Yes.
Okay. Well, I just want to start with that evidence. And so you didn't actually personally collect it?
I didn't collect it, but I looked over it after it had been collected.
Okay. Well, I'll start with the blue nylon fibers, and that was included in the evidence log, right?
Yes.
It said there were several fibers found on Hamea's clothing and body.
Yes.
Okay. And this type of nylon is open for all consumers to purchase. Is that correct?
Yes.
So it could have been transferred by any type of clothing that contained blue nylon.
It could have, but Michael is known to be wearing the blue nylon clothing.
You don't know a definitive time it got there, though, do you?
I don't know the time that we got there now, that they got there. So.
Okay. I just want to move on to the shoe print now. So the log also said that it was identified to be a size 9 Converse shoe. Is that correct?
That is correct.
And you weren't the person that determined the size of the shoe?
No, I was not.
Was the shoe was determined using the photo? Is that correct?
Yeah, photo.
And you weren't the person that took the photo. That was the CSI officer?
Yes.
Okay. And so being the one that didn't take the photo, you couldn't confirm that it was taken at the correct degree to determine its size?
I trust that our crime scene investigator took it the right way, but I can't tell you for 100% clarity that it was.
Okay. So next, there wasn't a definitive time that the shoe arrived on the scene. Is that correct?
No, but there was rain that led up until the day, so it most likely washed away anything else that was there.
But it was stained into the concrete. Is that correct?
It was, but most likely it would have been washed away by the rain if it was left before.
But that wouldn't, well, I guess I can move on. Let's talk about the fingerprints. So at this time, I'm prompting my co-counsel to screen share a clean and unmarked copy of Exhibit D. And I'll just need one moment for that to happen.
All right, Exhibit D is in David, fingerprints. There we go. You may inquire.
Okay, so these prints are familiar to you, correct?
Yes.
And do you know the specific finger by which these the print was taken from?
Can you repeat that?
Yeah. Do you know which hand on the finger the print was taken from?
No, I do not.
Oh, okay. And you weren't the person that determined the comparison, is that correct?
No, I was not. It was a lab that determined.
You didn't collect the print either, just to clarify?
No, I did not collect it.
And they used 12 points of similarity to find their answer, is that correct?
In this one, they used 7.
And is 7 the minimum amount of points that they normally use?
There is no minimum or requirement for anything. They found that 7 in this case was fine for this print.
And it was 7 out of how many points? It was over 150. Is that correct?
That's for a full fingerprint. And this partial print, there's a lot less.
Can you determine the number of possible points to choose from on this partial fingerprint?
You could, I'm guessing. That would be the lab's job.
But you didn't analyze the print, so you didn't do that. Is that correct?
I did not analyze it.
So I just want to talk about the thing that you actually did. You talked to Corey Abrams. That's correct?
Yes, I did talk to him.
And they told you that they saw someone fleeing the scene of the crime wearing a blue bomber jacket, skinny jeans, and high top shoes, carrying a gun. Is that correct?
Yes, that's what they told me.
That is the only piece of evidence you found linking a gun to Micah Opusay. Is that correct?
The gun, yes.
Okay. And it was 10 days after until they came in to do an official lineup in choosing who Micah was.
Yeah, it was 10 days after.
Okay. And so upon arriving to the scene of the crime, instead of reviewing the evidence and seeing as you're a master evidence technician, you instead chose to talk to the eyewitness. Is that correct?
Yes, because I figured they would have something important to give me, which they did have something important.
But you previously stated on direct how eyewitnesses can be unreliable. Is that correct?
They can be unreliable, but at this point, I still had no clue if they seen them right next up. So I had to make sure and see if they had anything I could use.
Okay. No further questions, Your Honor. Thank you.
Thank you. Any redirect on those questions?
No, Your Honor.
All right, thank you. All right, at this time, the witness may step down. Does the prosecution have any further witnesses?
Not at this time, Your Honor.
Right, thank you. At this time, are the parties prepared for their closing arguments?
Thank you, Your Honor.
Thank you. And I believe,
Your Honor, do we have?
yes.
Go ahead.
I'm looking at the time frame now. How long do they have for preparation before closing?
2 minutes.
Timekeepers? Thank you. All right, you may have your 2 minutes at this time, and I'll ask the timekeepers to start that now. Does the defense need any more time?
No, Your Honor.
Does the prosecution need more time?
No, Your Honor.
All right, so why don't we begin at this time? And Is the defense prepared for their closing arguments?
Yes, Your Honor.
All right, very good. I'll hear from counsel.
Your Honors, opposing counsel, may it please the court. The defending counsel humbly came before you today requesting that Micah Obuse's guilty plea in agreement to manslaughter and 10 years served be withdrawn as it constitutes a manifest injustice. On account of prosecutor Justice Okafor withholding evidence we've shown to be exculpatory today, and request this in light of the fact that the precedents set in previous establishments have been directly opposed by the prosecuting party on several accounts, from cases Brady v. Maryland and United States v. Begley. And I'll start with the precedents set in Brady v. Maryland. And it may be known that this is the case responsible for defining what constitutes a manifest injustice. And to alleviate any curiosities at this point, a manifest injustice occurs, meaning a retrial is necessary, only when evidence deemed favorable to the defense has been suppressed by the prosecution. And now we can further narrow in with the reasoning set in United States v. Begley, which voiced that the evidence suppressed, which would have to be evidence which, if used in the original trial, most likely lead to a not guilty outcome. And to put this into application, I'll start with the expert witness that was before you today, River Foley. Now, during the time on their stand, they discussed all the evidence that the prosecution deemed substantial enough in making a case against my client. So substantial that they could deem Corey Abrams' witness testimony update to be non-exculpatory or no big deal. But they started with the good hard evidence. I mean, it's the tangible evidence, to say the least. A thread was found near the food truck, which could have belonged to Micah or anyone else wearing that highly produced and highly affordable strain of material. And now next was the shoe print of oil, which very well also could have been there for weeks before Micah met Hamea for reconciliation. It was stained into the concrete. And who's to say it even was a size 9 shoe, considering it couldn't be confirmed today on cross-examination whether it actually was taken at a proper angle. So the last piece of tangible evidence discussed was the partial fingerprint on Hamea's glasses, which was only examined by one analyst who didn't adhere to the normal 12-point standard and instead only used 7. And much like the other pieces of evidence, only goes to show that Micah could have been at the scene. But this whole time, the prosecution bit their lip to discuss the elephant in the room. Did the investigators ever find a murder weapon, ballistics reports, bloodstain analysis? All of the evidence that would actually either incriminate or exonerate my client has seemed to fall through the cracks today. And so all we were handed were Kai Robbins' statement, which was way more prejudicial than probative and had no bearing on the manifest injustice that we're trying to discuss today. And the last event that I want to discuss. So Corey Abrams' testimony was given to Attorney Sticks with full understanding that Corey was positive that they saw Micah fleeing the scene of the crime. Now, with that information, Micah's counsel used what they believe to be a complete record of accounts in order to advise my client to take the plea deal. But after Corey voiced what a mistake they had made, Justice Okafor saw it important enough to update the change their deal from 30 served and murder 2 to manslaughter and 10 years served. But they didn't see it important enough to update the defense of this recantation. And a record that it would have otherwise compelled Micah to take the matter to trial. In a trial, I think we can all believe, would have never compelled a jury beyond reasonable doubt to find my client guilty of aggravated murder. And so if you choose to think back to the beginning of this trial, when my co-counsel Isabella Wood talked about the practices and precedents set to allow us to voice our transgressions against the state, whether Corey had their reasons for deeming, or whether the prosecution had their reasons for deeming Corey's witness testimony update to be non-exculpatory or no big deal, it just wasn't their call. And so I, again, humbly ask that you withdraw this guilty plea as we have upheld our burden of proof. And I see it to grant Micah a retrial, so an innocent man's name is tarnished no more. Thank you, Your Honor.
All right, thank you. Was there a rebuttal that you held with respect to your closing argument?
Yes, Your Honor.
All right, thank you. I'll hear now for the prosecution.
Thank you, Your Honor.
You're welcome.
Your Honors, may it please the court and opposing counsel, the state respectfully requests that Micah Opase's request to withdraw his guilty plea be denied. The Latin phrase post hoc ergo propter hoc translates to after this, therefore, because of this. And essentially it means that since one event happened, another effect took place. It seems simple on its base, but any philosopher will tell you that it is only true in the absolute rarest of circumstances. The defendant would like for you to believe that there was a Machiavellian plot to jail them for crimes they did not commit. But like the post hoc fallacy, this is only true in the rarest of circumstances, in which case it is not true today. The defense has suggested that their client was a victim of a due process violation under Brady versus Marshall, which was in fact about evidence withheld from a defendant in a trial before a jury. This we can surely agree on. But Campbell versus Marshall makes a clarification between Brady versus Maryland and our case. Because in this case, the Sixth Circuit Court of Appeals determined that questions regarding Brady violations were not pertinent to the case, but rather that the petitioner's guilty plea was intelligently and voluntarily made with the advice of a competent counsel. The difference between Campbell and Brady is that Campbell had to deal with the plea bargaining phase, whereas Brady versus Maryland is about an actual trial. And the manifest injustice that opposing counsel referenced in their closing was in fact about an actual trial as well. Unlike Brady, Campbell actually resembles the case we're here for today because it was about the plea bargaining phase. And this is important because today Micah told us that they understood the implications of their actions and that they trusted their attorney, Freddie Sticks. Furthermore, the Supreme Court unanimously ruled in Ruiz versus the United States that the Constitution does not require the government to disclose material impeachment evidence prior to entering a plea bargaining agreement with a criminal defendant. The protections under which the defendant is making their motion are intended to ensure a fair trial. And had Micah gone to court, Justice Okafor would have had to disclose Corey Abrams' reservations. But because a guilty plea is a waiver to trial, Brady and Giglio do not have application, but rather Campbell and Ruiz do. They make the distinction clear, and under their rulings, the prosecution had no obligation to turn over Brady evidence during the plea bargaining phase. Today, the defense was required to prove beyond clear and convincing, required to prove with clear and convincing evidence that a manifest injustice occurred under Rule 32.1. And after referencing the case file, it is not true that they did this. Today, they called Micah Opase and Charlie Nguyen to the stand, and Mr. Nguyen and Mrs. Nguyen came prepared today to explain how they conducted their investigation. What they failed to explain was that they possessed incredible confirmation bias, as they were not just paid by the plaintiff, but paid double by the plaintiff. Furthermore, they made several dangerous claims today regarding evidence, which, if adhered to, would take away a necessity for a judicial system whatsoever, much less laws. And Micah Opase told you that they pleaded guilty without being misled, and that their attorney was aware of Justice Okafor's reservations, but still moved forward with plea negotiations. Today, we ask you to turn your attention to Kai Robbins and River Foley. They both provided us evidence today that Micah Opase did in fact murder Kamea Robbins. Mr. Robbins explained Micah's threatening behavior and prior threats against Kamea, while Detective Foley gave us the material evidence against the plaintiff and showed how it outweighed one eyewitness identification. The opposing counsel also attempted to insinuate that this was just teenage angst, that this was just drama, that this was just someone being overly melodramatic, in fact. And they also said that their poetry was really just prose, it was innocent dirges, but in fact, I would suggest that if you think poetry can be innocent, that you read Howled by Allen Ginsberg and then come back to this. Today we're talking about someone's life. We're not talking about teenage melodrama. We are talking about Kamea Robbins' life. We are talking about the memory of her. The streets of heaven gained an angel on August 31st. Micah Opase committed an irredeemable crime. He cut short a life. They cut short a life such as Kamea's, and in doing so, they robbed the earth of endless possibilities and limitless potential. They see this as their way out. In response to this, the prosecution offers a quote from the poet laureate and Nobel Prize recipient Bob Dylan: "When you ain't got nothing, you got nothing to lose." They see this as their way out. We can't let them have it. That is all, Your Honor.
All right, thank you. Having concluded the trial at this time, I'm going to ask the timekeepers.
Your Honor,
Oh,
I
I'm
believe I
sorry.
have the opportunity to give a rebuttal.
Yeah, I'm sorry, Parker.
No, you're fine.
I apologize. I did ask and you did reserve. So why don't we go ahead with the rebuttal, and I'll ask timekeepers to begin timekeeping. Thank you.
Thank you. Opposing counsel, Your Honors, may it please the court. So, Your Honor, the defense first claimed in their opening statement they would have to prove two-step stipulations based on past precedents. They claimed that we would have to prove that there was a manifest injustice in failing to close Corey's witness statement to the courts, and that testimony would have had to likely change the verdict of the trial had it been disclosed and had it gone to trial. But the problem with the prosecution's request of us to carry our burden is that nowhere in our trial are we attempting to prove that Micah's decision wasn't made knowingly, intelligently, or voluntarily based on the suppression of Corey's statement. In fact, it was made very clear on both recross, cross, and direct that Micah was made aware of that statement during both plea deals. But we're not arguing a manifest injustice based on the witness testimony, had it been true. It is the recantation which we are stating led to an unintelligently, unknowingly, and involuntarily given counsel. And had Micah known about the update to the testimony, not just the testimony itself, because it was already known about, Micah clearly stated that they would have taken the matter to trial. And they were given counsel based on the idea that Corey's identification was accurate, which we know to be false today. And therefore, there was an unintelligently and unknowingly understood plea that was taken based off of incomplete record. And while it was stipulated that certain pieces of evidence in United States v. Ruiz did not need to be disclosed if it was in regards to plea negotiations, the prosecution is still required to disclose any evidence that would be used had the defendant insisted upon a trial. So basically, seeing that the evidence suppressed in question was Corey Abrams' witness recantation, it's highly unlikely the prosecution would have continued to the trial with the same claims that Corey was positive they saw Micah fleeing the scene of the crime. So that's why I request that you grant this retrial and see it that Micah is given a second chance. Thank you, Your Honor.
Okay, thank you. So again, at this time, we're going to ask the timekeepers, have there been any major discrepancies here during closing arguments?
I don't believe there were time discrepancies in opening or closing arguments. Rather, there might have been some during direct examination of the defense witnesses.
Right, and I took note of that on the record and allowed the finish of that statement. But Ms. Williams, anything that you find as a discrepancy?
No, I did not find it.
Okay, thank you. All right, at this time then, the scoring judges will remain off camera, and I'll allow the parties 3 minutes. Does either of the team have any serious reason to believe that a material violation of any rule has occurred during this trial? I'm going to remain here for 3 minutes, during which time any protest or objection may be brought to my attention by a team attorney. The team attorneys may communicate with any student team member involved in the particular trial, but may not communicate in any way with legal advisors, teachers, or anyone outside their performing team. And so at this time, we'll ask for 3 minutes to start, and I'll let the lawyers and their teams have some discussions before I come back on and ask if there's any material violations. Thank you.
Every single person.
We have no discrepancy, Your Honor.
No discrepancies. Thank you. With respect to the opposing counsel, if you need more time, you still have it.
We had no discrepancies, Your Honor.
Right, thank you. All right, so at this time, we will have an opportunity, with none being levied, that I'll ask the two scoring judges if they have completed their opportunity to submit, if they want to come onto the screen here. And I think each of us are given 3 minutes, and timekeepers are supposed to be timing us on this as well. So why don't we hear from both of our scoring judges? Burrell, if you want to go first, and then Matt, maybe you can go second. Thanks.
Sure. I'll be pretty brief because I don't know, it looks to me like we're over time, but maybe we're okay. I thought overall, both teams did a very nice job. I know that all of you have at this point had lots of experience doing virtual things, but even so, doing a competition like this in a virtual environment is a whole unique set of circumstances. And I thought all of you did very well navigating, especially questioning witnesses. You know, it's not exactly the most natural thing to have a dialogue with somebody and try to make it sound conversational when you're doing it over Zoom. But I thought you all did a very nice job navigating, and even navigating through some of the technical glitches that we had. It was clear that you were well prepared and well organized. And I would just, I guess, say to all of you, if this is something that you found enjoyable, it's a really good opportunity to get just kind of a taste of what it's like to work as an attorney, or to, for the witnesses, I guess, to get a taste of what it's like to act, if any of you are in theater programs. But if it is something that you found enjoyable, find other ways to get experiences like this. There are lots of opportunities that are out there. I hope this was a positive one for you. I'm glad that it was still available to you this year. And I would just thank all of your teachers, your advisors, your family who helped make sure that you could participate in a program like this, especially in a year like this. So good job to all of you.
Thank you. Matt?
Thank you, Judge. Terrific performance by both teams. The attorneys were incredibly well prepared. The witnesses knew their affidavits and knew what was in them and what was not in them, and knew the exhibits. Absolutely tremendous performance from both sides. And it's clear that you were very well prepared and ready to go today. And just congratulations on a terrific performance. And to top it all off, you got to practice before an acting judge, and you held your own and did a very nice job. And so I can't even imagine the pressure you all felt going into this, but you pulled it off tremendously well. So congratulations and best of luck.
All right, thank you. So mine will be just as brief, but man, I think that all three of us keep coming back as judges because we truly enjoy this. You know, just imagine on a Friday morning where anybody else would be, whether we're doing billable hours or looking at different things. We are here with you, and we really enjoyed it. So, I mean, at 8 o'clock, and now it's 1:45. I don't know where the time went. You guys kept our interest, and you guys were just fantastic. So, again, as I said at the beginning, all the hard work you put into this paid off, and this is extracurricular, right? And so it's not something that. So great to all of you, and congratulations, just a round of applause. And I think we're done. So good luck with whatever happens down the road as well. I think according to the list, we just hit leave, and then all of us are zoomed out. So thank you all. I really appreciate your time. Good luck.